Yeah. Good afternoon to all the GST enthusiastic and those who are eagerly waiting for the GST Appellate Tribunal. This is the session where we will be listening to our learned faculty Bhavna Maheshwari on this topic of statutory provision, code of conduct and procedures of GST Appellate Tribunal. So before going to Bhavna ma'am, let's have our words of wisdom from the chairman of our GST committee, who is our beloved RK sir, and he is reporting, or he is, we cannot say reporting, but he is there in Nagaland. So over to you, sir, for your words of wisdom. Unmute,
Thank
sir.
you. Yes, thank you, Honorable Vice Chairman, sir, CA Umesh Sharma ji, for the introductory remarks. CA Bhavna Maheshwari, our very esteemed faculty, and our staff of ICI Impreet Kaur, who is there online, technical support people who are there. First of all, welcome back to Umesh Sharma ji for his visit back to India from USA. He had a very fruitful visit to the United States of America, where he got an opportunity to visit the Microsoft headquarters for the purposes of discussion of AI related issues regarding his committee. And we only hope that these things which he is undertaking these initiatives will certainly help members and ICA in a long way. As the chairman of the AI committee, he has been really in the forefront of the AI initiatives of ICAI. So thank you, Umesh ji, for being extremely dedicated in those lines also. Today's webcast is by CA Bhavna Maheshwari, a very young, energetic chartered accountant. So, welcome to you, Bhavna ji, and I greet you on behalf of the committee also. The topic is very important topic that has been chosen, which is relating to the GST tribunal. In fact, the tribunal is the buzzword. We only hope that very soon, maybe on the formation of the GST day, the first tribunal rolls down and the officers are appointed, the judges are appointed. Nevertheless, the tribunal practice will be of immense value to chartered accountants. As far as the consumption taxes are concerned, there cannot be a day when we feel that there is no change happening, when there is no new dispute arising. In fact, consumption taxes, as large they are also as large disputes within themselves. The day we basically understand consumption taxes, we find the disputes also come along with it. They are both on one or both sides of the same coin. So we'll have Bhavna Maheshwari ji, who is going to treat us basically on the important provisions going forward. And you, the members, about 700 plus members who have joined today, really immensely thankful to all of you for joining and also for supporting us in our learning initiatives. As Umesh Bhai said, I am in Nagaland today. We are actually offering training to the state tax officers of Nagaland. In fact, whatever is the size of the state, whatever is the size of the revenue, for ICI, it is the training to the officers that matter. For ICI, it is the knowledge dissemination that matters. So in the second 8th year, 8 years of GST have been concluded. In the second 8th year of GST, we will find the knowledge flows like a river, and we have people who are equipped with facing new ideas and new challenges. We from the GST committee are second to none. Our publications, our webcasts, our seminars, our certificate courses, and our reach to the government, which is very important. We have an excellent reach with the government as far as GST is concerned, and we'll continue to add value to that also. Thank you very much. And once again, a warm welcome to each and every one of you on this webcast. Over to you, Umesh Sharma ji.
Thank you, sir. And friends, please appreciate our chairman's vision. He is training our member as well as the officers. So both side of the coin has been well balanced by our chairman, sir, by imparting knowledge to officers as well as to our members simultaneously. So this is the vision of a visionary person who is living by GST day in and day out. So thank you, RK sir, and take care of your health. Because of your hectic schedule, we always worry that, sir, today in Nagaland, tomorrow in Delhi, and day after that in Ahmedabad. So it's a big task. So God bless you, sir, with a good health. And with our back to topic, now we come down to introduction of our speaker, Bhavna Maheshwari. Friends, as the name suggests, आपको जीएसटी ट्रिब्यूनल की क्या भावनाएं हैं वो समझ जाएगी आज के वेबिनार के बाद. शी इज हैविंग अ वेरी गुड एक्सपीरियंस ऑफ जीएसटी subject. She is a master, 10 plus years of experience in this particular subject, and she represents various organizations on various forums of litigations, appellate tribunal, and most important, she is always ready to share knowledge and addressed as various forum of ICI, also a proud member of GST committee. So Bhavna ma'am, you are welcome to express your Bhavna to all our members on this subject.
Thank you so much, sir, Rajendra sir, and Umesh sir, for first of all, thanks to ICI for giving me this opportunity and to present my insights on the recently introduced GST rules and procedures. As we all know, we are all so much struggling with and awaiting, eagerly waiting for the GSTAT to come into existence. And with that, I thought we all, since the procedures are already ruled out, so everyone would not have got a chance to go through. So along with me, I can at least take through the audience, the attendees, through all, walk through them through the rules and procedures, so that once the GSTAT is in existence, we are aware about what were the rules, procedures, and how we have to take up. So I'm immensely honored for this opportunity, and thank you so much for believing in me. So I would just now start. Before we start, I just want to mention that since we have around 124 rules to this presentation might take a while. Please be patient, everybody, and be with me until the end. We can take all the questions in the end, since there are a lot of rules and procedures to be taken through. So we can, I will definitely give you a window to throw your questions. You can keep posting your questions in between. We will take up all in the end once we are through with all the rules and procedures. So I hope my screen is visible.
Yes. Yeah, visible.
Okay. So yeah, so this today's session will be, we will be covering the GST tribunal rules and procedures and the sections. Okay, so we already know that the section 112 was already into existence, which lays down the relevant relevant procedure, not the procedure, the sections, the regulations for the filing and appeal to the GST tribunal, right? Now what has happened is, in the on April 24, 2025, the civic has also rolled out the rules, which are around 124 rules, as I already mentioned. So these rules will be these are extensive rules clearly stating out the entire procedure for how we have to file the appeal, how many members, what would be the qualification, so on and so forth. So we can just start with what I will just start with how, what is the GST tribunal? Why was the GST tribunal? Okay, so what is a tribunal? So tribunal is a quasi judicial institution which was set up earlier to expedite the process of clearing the cases, tax related matters or other administrative matters, because there were a lot of matters which were getting accumulated with the high courts and the supreme courts, and there were a lot of pressure on the high court and the supreme court to clear these cases. Hence there were that's where the tribunal was brought into existence. So the major need is for the speedy trial of the cases, and to ensure that the specialized decisions are given, and they can. So these tribunals are more, we have several tribunals, I'll take you through that. So presently this is this has come through the word tribune, which is from the Roman officials, which specifically means the arbitrary actions of the magistrates. So the word tribune was derived from the word tribunal was derived from the word tribune, which has been come from the Roman legislature. So now I would if just tell you that how the tribunal came into an existence. Initially, the tribunal was has no existence in the Constitution of India when the original Constitution was drawn. However, after that, during to the 42nd amendment, the constitution was amended, and there was a article 323A and 323B which were introduced. 323A was for the administrative tribunals, and 323B was for the other matters of the tribunal. So actually, when the lot of when as I already mentioned, there were a lot of cases which were getting accumulated with the Supreme Court and the High Court. That's where they have felt the need of forming a tribunal, and that it was formally entered into the Constitution by the 42nd Amendment. So these are, as you can already see on the screen, we have there is a screenshot of article number 323A and B. I'm not going through the details of these articles. So, after this tribunal was brought into the picture, there was a dispute that will this tribunal exceed the authority of high courts and supreme courts. So, in one of the case which was between Union of India and Mr. this Lal Chandra Kumar, it was mentioned that the tribunal will be functioning as a specialized body, but it will not replace the High Court or the Supreme Court. It will still exercise it will just be a body which will be deciding cases, but it will not be on behalf of High Court or Supreme Court. Supreme Court and High Court uh, will always have a jurisdiction over the tribunal, and the cases will always be referred to the High Court and Supreme Court ultimately. So this was the famous judgment of Lalchand and sorry, L. Chandra Kumar. Now, I will just, this is the screen which is showing that there in India, how many tribunals are in India at the moment. So we have various tribunals around 12, 12 to 16. I have listed only few here, not all of them. So as we know, ITET is there. Then we have CESTAT. We have CAT, Central Administrative Tribunal, which is having 19 regular branches and 33 circuit branches. We have DRT, which has 39 tribunals across India. We have National Green Tribunal, which is established in 2010 and which has 5 benches. National Company Tribunal (NCLT), which has 28 benches. SAT. We have State Administrative Tribunal, which is addressing the matters related to the state government employees. We have NCLAT, which is basically hearing the appeals of NCLT and coming from the Insolvency and Bankruptcy Board of India and the Competition Commission of India. We have SAT again. This is Security Appellate Tribunal, which is addressing the issues coming from SEBI and other financial institutions. Then we have Intellectual Property Appellate Board addressing the appeals related to patent, trademarks, and other intellectual property matters. Then we have NCRDC, which is addressing the matters of which is coming from the consumer disputes. So these are the few tribunals which we have listed in India. There are few more, but since already the content is too much, so I haven't put it here. So moving ahead, this is basically a hierarchy which is presently in India for the GST litigation. Actually, it originally starts from the scrutiny of returns, which is ASMT 10. However, the real adjudication starts from the SCN level. So as we can see, we get a show cause notice in form DRC 01, and we reply in DRC 06. Then order is issued in DRC 07, and we file appeal against any order in GST APL 01. Then once we receive the order, first appellate order, then the order in appeal is in APL 04. Now appeal to tribunal in form GST APL 05. As we can see that I've already mentioned that since GST has come into existence in 2017. However, till date, we can see that the tribunal is still not into existence. I think almost now 8 to 9 years we are completing, and we are still waiting for the tribunals to come. And we all know that how many cases have got accumulated only on the grounds of uh, rejection of orders because of late filing of appeal. So there could be so many cases. I think 30-40% cases could be on the same grounds apart from the legal matters. So we are still waiting for the tribunal to actually come into existence. Now, order of GST tribunal, which the appeal will be filed to the High Court or the Supreme Court. Then High Court, once the appeal order is by the High Court, the appeal is to the Supreme Court, and the last stage, of course, is the Supreme Court, which is the law of the land. So before we start the presentation, I would just quickly want to run through everybody through the crucial timelines of this entire GST tribunal journey. So GSTAT provisions actually came into existence in July 2017. Then in September 2019, the Madras High Court GSTAT provisions there was a case law which has where there was an objection actually filed by the advocates in September 2019, wherein the Madras High Court had held that the GST provisions are unconstitutional, and the qualification of the judicial members and the advocates should be allowed to be the judicial members. Initially, the advocates were not allowed to be the judicial members. However, after this Madras High Court judgment, they have referred this matter to the Parliament, and the Parliament has later on allowed this, and the advocates were allowed to be the judicial member. Okay. Then in September 2021, the writ was filed in the Supreme Court, same allowing the advocate members to be the members of the GSTAT. Then in March 2023, there was a defect in the constitution of GSTAT, and the correction was made stating that the qualification, making changes in the qualification of the judicial and technical members, where they've decided that 4 members will be there in total, and 2 members would be technical members and 2 members would be judicial members. In December 2023, finally, the GST Act was amended to allow the advocates to be the members of GSTAT and revise the age limit criteria. In May 2024, the first president of the GST Stat took oath. Then in July 2024, the timelines for filing the appeal before the GSTAT was revised, and the 3 months time period was notified. Then in 2024, in August 2024, the principal bench of the at New Delhi was established. In November 2024, various other branches, along with the notified branches and circuit branches, were also established, were notified. And now in April 2025, we have already got the rules and procedures. So these are the few important highlights, the timelines, which are crucial in the entire GSTAT journey. Now coming to the section 112, which highlights that when and why and how, which we will be filing appeal to the GST Appellate Tribunal. So 112 section has 1 to 10 subsections. I am not presenting all the sections here. Few I have highlighted here. So we will go through it one by one. So that as we can see, any person who has been aggrieved by the order passed by the first appellate authority under section 107 or 108 can file the appeal again to the appellate tribunal against the order of such authority within 3 months. So, from the date of order in which the order was communicated. Now, this word communicated has already been clarified. What do we mean by the word communicated? Communicated has already been clarified in section 169, which states that how and in through what modes an appeal an order is said to be communicated. So there are various modes like by post, and then the if it is delivered by registered post, if it's sent by mail, if it is communicated through on your registered premise, if it is hand delivered. So all these modes which are already covered in section 169, we are already aware about it, are all the proper modes which where it could be where it will be said that the order was communicated to you. So the 3 months from there shall be counted. Also, they have given that if the council notifies any other time period for such filing of appeal, the later would be considered of the two. So, the 3 months from the date of communication of the order, or as the date may be notified on the recommendations of the GST Council, whichever is later, shall be communicated, shall be the date of filing of the appeal. Now, we can also see that now for filing of this appeal presently, as we are all aware that there is no GSTAT in existence. So what are we doing right now? I think almost all of us must have received order. Now we are already in the process of receiving orders for 17, 18, 18, 19. So from the first appellate authority. So there is a circular 224 by 18 by 2024, which was in dated July 11th, July 2024, which clearly stated out the process to file, not exactly file the appeal, to file an application to the GSTAT once, so that for to stay the recovery proceedings. So all the details that this circular has listed out on how we will be adjusting the pre-deposit, because we all know that even for the stay recovery we have to pay 10% of the pre-deposit. So how that pre-deposit has to be paid, if in case most of us usually pay through the ITC, through our electronic ledgers. However, if somebody has paid it to the through DRC 03, the circular also states out that if you've paid through DRC 03, we can always link it through DRC 03A, and we can adjust, get it adjusted, that the payment will be automatically reflected against the appeal. And we have to make one application to the GSTAT and to the officer, stating that we would want to contest this case with the appellate authority, hence request you to, and we have already made the payment of the pre-deposit, hence we request you to stay the recovery proceedings until the GSTAT is coming into constitution, existence, or maybe operation. Now, if the appellate tribunal has been allowed the power to not admit case which are not exceeding 50,000 rupees, in which the ITC difference or the ITC involved is less than 50,000 rupees. Now, this also or the amount of fee or penalty is also less than 50,000. So they may say that we refuse to admit such cases. This is on the revision, that if the commissioner feels that they have upon the request of any state commissioner or any union territory, that so that they can call and examine the record of any order passed by the any appellate authority, and they can go through that and they can see the legality of the orders passed, and for the just to satisfy themselves, and within 6 months from the said from as we can see, within 6 months from the said order passed, they always have the power to rectify that, to revise that order. This power has been given to this power is with the commissioner. But there are provisions which allows the delegation of these power to the commissioner, to the state commissioner, union territory again. Yeah, sorry, I think there was some issue. Yeah, so on like filing of appeal. Now, how we have to file an appeal? The procedures are obviously we will take up the procedures in what form, in what manner, which will be covered in the rules. However, this is stating about the how in how many days we have to. The cross objection can be filed. So if there is a appeal which is filed, then notwithstanding anything, the any appeal which is to be made against the order which is filed, which is passed by the appellate authority, within 45 days a memorandum of cross objection shall be filed with by the and it will be disposed of in the manner as decided by the appellate tribunal. Again, so this is again stating about the cross objections, as we all know. So cross objections, I hope we are all aware, once we file an appeal and if the order is passed in favor of either of the petitioner or the respondent, then whomsoever the order was passed in favor, the other party to the appeal can, or the order can always go into the cross objection, and they can file this the appellate will admit this cross objection within 3 months after the expiry of the period. But again, as it is mentioning that if there's a sufficient cost, we have to give a sufficient cost for not to be presenting if we want extension to this period. Payment of pre-deposit. So e- even if today we are filing any appeal to the first authority, so the pre-deposit is mandatory. So the pre-deposit earlier was around 20%. However, the government has reduced that pre-deposit now to 10% specifically, and there is a maximum and minimum capping also on the pre-deposit. So no, the section 112.8 highlights that no appeal will be filed unless and until there is a pre-deposit which is paid. So even if we see now, you are not able, if you are not making the pre-deposit and you're filing an application to the your concerned officer who has issued order, the first appellate authority who has passed the order, if you're not filing an application and mentioning that the pre-deposit has been paid, they will start the recovery proceedings. So the pre-deposit payment is mandatory. There are judgments which we have covered in the later stage of the slides, that which covers that the pre-deposit of was waived, but those are exceptional grounds. Otherwise, in general nomenclature, we have to pay the 10% pre-deposit. So the pre-deposit shall be in the amount of tax fee, tax, interest, fine, uh, and the penalty arising from the impugned order as admitted, and a sum equal to 10% of the tax amount. So right now also we are all paying 10% of the tax amount. It is never on interest component or never on the penalty component. So again, it's they have kept this in as par to the first appellate authority. Considering the challenges of the businesses, the pre-deposit amount was reduced from 20% to 10%, and the reduction in the maximum amount of pre-deposit was also made from 50 crore to rupees 40 crore. Sorry, 20 crores. Again, this is mentioning about the pre-deposit, that the only a sum of rupees of 10% is to be paid under section 107(6), and then only the stay recovery proceedings will be stayed. So I have already mentioned that in my earlier slide, that until the pre-deposit will be paid, the stay will not the stay proceedings will not be held. This pre-deposit also shall be adjusted. So one more point is that once we pay this pre-deposit right now, and when actually the GStat comes into existence, the this pre-deposit will be adjusted against the final order passed by the appellate tribunal. So this 10% will be first deducted from that, and then the final order demand would be pronounced. Now we are coming on to the how and this appeal shall be filed, the form and manner of appeal. The appeal to the appellate tribunal shall be filed in APL 05. The order is received in APL 04. Appeal shall be filed in APL 05, and it has to be filed electronically. Now, if in case we are unable to file it electronically, the manual filing is only allowed with the permission, with the special permission from the registrar. So until then, you are not allowed to file it manually. Okay, then the appeal filing will be considered only final when the acknowledgement is generated. As we see that in the present APL 01 is the, we get once we file the appeal, we get APL 01. Similarly, in this case also, we see that APL 05, we'll file the appeal and then acknowledgement will be generated. So hence, please, everyone has to ensure that you are receiving the acknowledgement, and if you're not receiving, we have to file the grievance. Now, one more thing which they have added here from the last SISTAT is they have added the filing fee, which is rupees 2000 for every 1 lakh, which is not a small amount, because there are companies which may have crores of liability. So again, but the good part is they have capped that amount to rupees 50,000, and a minimum so the minimum fee filing maximum filing fee would be 50,000, and the minimum, it will be at least 1,000 rupees per rupees 1 lakh of the tax or the ITC involved, or any difference in tax or any issue involved. In case where there is no tax, interest, and penalty, the fee filing shall be 5,000. So a minimum 5,000 filing fee is mandatory. Now this is appeals to how it happens. So when sorry, yeah. So section 112(1), as we have already seen, that we have 3 months to file the appeal. So if say there is a unfavorable order which is passed, so we have to file an appeal against form DRC 07 in APL 05, and then the pre-deposit is 10%, and 100% of the tax of the amount admitted, which can be deposited by either the cash ledger or the credit ledger, or the mix of both. There is no restriction on so. However, the maximum amount of pre-deposit shall be 40 crores. Filing fee, as we have already seen, it would be CGST and SGST, I think 1,000 rupees, and IGST would be entirely 2,000 rupees on per 1 lakh. And again, this is stating out what we have already discussed in the earlier slide, that the minimum amount of penalty fee, filing fee would be 5,000 to 10,000, and a maximum would be 50,000. Now these are the due dates, which we have already seen. Again, the condonation of delay, we have the condonation of delay is also allowed right now also in the first appellate authority. Similarly, the condonation of delay is also allowed while we file appeal to the appellate authority. we have to provided we are giving proper reasons of the non-filing of for non-filing of timely appeal. We all are aware that the condemnation of delay may or may not be accepted by the appellate authority, depends, it's all totally on their discretion. Now, powers of the tribunal. So we all know that the tribunal right now also has the powers of the civil courts. Okay, so similarly, they have the powers to issue summons. They have the powers to alter, uh, to issue the orders and call for hearings. They have all the powers to modify the orders. So similarly, these are the again few actions which can be taken by once we file the appeal to the appellate tribunal. So they can confirm the order. Confirming of the order, we all know the what does confirming an order means. If the tribunal finds that the appellate that the order passed by the first appellate authority was good and just and proper, they will confirm that the same decision in their order. If the tribunal considers that the appellate authority may have considered, the first appellate authority may have considered few cases, a few contentions of the assessee taxpayers, and they have not considered, so they can always modify those orders and they can issue the modified order. They can annul the order in full and cancel the quash the full order. Then very important that they have the power in under section 113(1), they have the power to refer back the case to the original adjudicating authority, which is very important. I think most of the cases when the GSTAT will come into existence, will be operational, there would be huge amount of cases which would come as a plush to the tribunal, because all of us are waiting for the tribunal to come into operation. So many cases will be referred back to the fresh adjudicating authority, especially the cases which were confirmed on account of delayed filing of appeals and were not heard. Especially those cases at least will be referred back to the fresh adjudicating authority. Hearings. Now, adjournment of hearings. As we see today also till date, we have, even if SCN hearing, even if it's a first appellate authority hearing, we get at least 3 hearings is mandatory to be given by the department. Therefore, similarly, the appellate tribunal will also grant us 3 hearings if the sufficient cause is shown again. So, but even though if we have all seen that, even though the cause is uh, not severe, also usually the adjournment is allowed at least for the 3 times. After the third time, yes, of course, it is on their discretion. They may most likely deny it, or if again the cause is sufficient, they may also allow after the third time. So this is about the adjournment. Now the rectification of orders. If there are any rectifications which the uh, department feels, if the tribunal feels that there was any rectification in their own record in the order issued by them, they may rectify so within 3 months from the date of order. Now we are coming to section composition of the tribunal benches, which is again in the as I already mentioned, in the initial issue in the initial constitute in the composition, the judicial members were not advocates. They were not allowed to be advocate. The advocates were not allowed to be judicial members. However, after amendment, after the Madras High Court judgment, the advocates were also allowed to be the member of the judicial members. So as we can see, there would be principal bench. So first we should know how many benches would there be? So there would be one principal bench established in New Delhi. There would be 29 benches covering 36 states, which are established in notified, which we will see in the next slides. So 29 benches covering 36 states, including the circuit benches. Now, all the appeals will be filed to the to the state benches of the respective states. The principal bench would be hearing the cases only pertaining to the place of supply and anti-profiteering. Apart from that, all other cases shall be given to the state benches. The any cases which are other than the place of supply and anti-profiteering in the state of Delhi shall be referred to the Delhi State Bench and not to the principal bench, just because the principal bench is based out in the Delhi. So principal bench will be strictly handling only place of supply and anti-profiteering matters. And so now we come on the composition. We can see that the number of members are would be 4, out of which 2 would be judicial members and 2 would be technical members. In the principal bench, there would be 1 judicial member and 1 president. In the technical members would be 1 technical member, which would be in the center, and 1 technical, which would be from the state. The state bench, there would be 4 members, 2 judicial members again, and 2 technical members, similarly as replicated from the principal bench. As we all know, we are aware that Sir Sanjay Kumar Mishra, Sir Sanjay Kumar Mishra has been appointed as the GST Tribunal President, and he has taken oath on 6th of May on 2024, which I've already mentioned in the crucial timelines of the GSTAT. Now, we have in November, there was a list in November 2024, there was a list of benches which were notified by the government, by the CIBIC, in which the circuit, in which the jurisdiction of the courts will be, the tribunal would be. So the first column already which states that the main principle, the branches, the state branches would be, and what would be the jurisdiction of these state branches. In the third column, fourth column, we can see that these would be the jurisdiction branches, and how many jurisdiction branches would be in which city. So as we can see in Mumbai, we will have in 2 locations, Mumbai city and Mumbai suburban. And in Pune, we have a list of all the cities, which there would be a proper jurisdiction district tribunal. Now in Panji, we can see there would be only circuit tribunal. What do you mean by circuit tribunal? It is only on the basis of the temporary. These are the tribunals which are constituted temporarily and only for the deciding particular matters. Rest of the time they are not operational. So in Panji, it would be only circuit tribunal bench, and in however in Thane it would be a proper sitting branch. So this is the difference between the regular and the circuit bench. So we see that the jurisdiction, all these Mumbai city will have the jurisdiction in the state of Goa as well. So all the districts in the state of Goa will be getting covered under the Mumbai city, and Thane will be covered in the Pune jurisdiction. These are the list of the cities which are covered in so again, if we see, Chhatrapati Sambhaji Nagar is again a sitting bench. They have already constituted a proper sitting bench in Chhatrapati Sambhaji Nagar also. So we have so many benches which will be constituted. This is the composition of the bench, especially for the state of Maharashtra. Okay, so we can see that the principal bench would be based out in the New Delhi, and the state benches would be in all the respective states, as we have seen in the previous slides. All the matters which will be relating to place of supply and anti-profiteering would be going to the principal branch, and finally would be decided by the Supreme Court. And any other aspect relating to the question of law shall be decided by the High Court. Now there is one open question. There are few open issues relating to that. That would the matter pertaining to IGST on import of goods will be heard by the GSTAT or the SISTAT. So we are yet to receive all these clarifications. There are, although the government has listed out the procedures 100 in 124 rules, still there are a lot of gaps and a lot of questions open loops which are yet to be answered, which I am sure that we will keep getting further circulars or clarifications certainly from the civic on such issues. Now the how the work shall be distributed. So the president will be deciding how the appellate tribunal will be operating between the state benches and between the principal bench, and how the cases will be transferred from one bench to the another bench. In the further slides we will also see the how the powers of one member can be transferred to the another member. Okay, so the all the this power resides with the president. The vice president would be the senior most judicial member with the state of the state branches, and he shall be acting vice president for all the state branches, and he shall also exercise the power as presidents wherever and as may be prescribed by the authorities. Again, now this is a very important rule 109. So in rule 109, earlier the this limits has been revised which were not earlier. So the earlier the limits were 5 lakh. So these are the decision making, how and what kind of cases will be decided with which authority. So where the cases are not exceeding 50 lakh rupees, and whereas there is no question of law involved, then a single bench, the single bench member can also hear the cases only with the approval of the president. So we have earlier this limit was 5 lakh rupees. However, now they have amended it to 50 lakh rupees. This has been revised now in the rules and procedures. So it is very important that when the amount involved is not exceeding 50 lakh, and where the question of law is not involved, then only the single member bench will be able to decide, but only with the approval of the president. In all other cases, the judicial member and the technical member will together decide the matter. All other matter would, which all be obviously exceeds 50 lakhs, or if it will be a question of law also, and if it is below 50 lakhs, then it will be certainly decided by the technical member and the judicial member, and then it will not be decided by the single member. Now the division, there would be a division bench also. So the division bench again would have the division bench would be deciding the case, which would be where the order appealed against rupees 50 lakhs and above, and the matters involving question of law. Now the decision making process. In the decision making process, this is very important, because in the decision making process there are rules which state that how the powers will be transferred from one bench to the another bench. So first of all, in case there is any difference of opinion among the members, the president shall refer the case to the state bench matter. If there is a, in case of the state bench matter, if there is any difference of opinion between the members, it will be referred to another bench. Or if another state bench is not there, then the matter will be given to the member of the another state bench. Okay. Then if it is the matter of principal bench, then the principal bench will be transferring this matter, may give this matter to the state bench if it feels so, or it where there is first it will be giving to the principal bench only, the another member of the principal bench. However, if the another member is not available, then only it will be transferred to the state bench. Now, so how this will be decided? What is the I have earlier missed out in my other earlier slide, that what is the monetary limit actually to file the appeal to what is the monetary limit to file the appeal with the GSTAT? For the taxpayer, there is no monetary limit. We can file appeal to the appellate tribunal even if the matter is involving rupees 10. Okay. However, for the revenue, the the monetary limit is rupees 20 lakhs, subject to any exception, which will be again decided by the appellate tribunal. So the monetary limit will be based on the total amount in dispute. It will be based, so this 20 lakh rupees would be based on the total amount in dispute, means what? Tax plus interest plus penalty. Any of so for the revenue, again, tax, interest, penalty, if it is below 20 lakh, the appellate tribunal may decline the admission of the appeal. But however, there is no monetary limit for the taxpayer. So also in continuation to this, the decision making process, the authorization of these decisions to pronounce the decision may be given from one member to the another member, as we have already seen. So if the tribunal feels that the decision is to be given from if the tribunal of the press or the president may authorize any member to pronounce the order on behalf of the other member also, if that particular member is not present at that moment, and after being satisfied that the order has been duly prepared and signed by all the members who have heard the case. So all this not mentioned on the slide. However, Rule 105 states the authorizing of any member to pronounce the order, the powers. So now we are seeing the appointment of the members. Again, so this appointment, this entire section is very important on to whom can be the judicial member, who will be the technical member, who will be the technical member in the center and the state. So as we can see that the judicial member would be the judge, the principal member would be the judge of the Supreme Court and the Chief Justice of the High Court. Now, if we see that the term is 4 years plus 2 years, that means 2 years could be extended. Ideally, it's 4 years and plus 2 years if they wish to extend the tenure. And the age limit, we have to see that why they have kept such a higher age limit. This was also actually disputed in the Madras High Court judgment, where they had reduced this age limit. However, still the reduced age limit also looks like 50 years. So we have to see the minimum age you have to have is 50 years. Only when you are 50 years, you can be part of the principal bench member. Then judicial member, again, we can see he has to be the judge of a high court and 10 years of the combined experiences. That means he has to be at least an additional district judge, or at least the district judge for 10 years. And it is not highlighting only the tax matters, it is mentioning that he has to have a combined experiences of not just the tax matters alone. He could be attending any others matters also. How but the 10 years of experience of district or additional district judge is mandatory. For judge of the high court, there is no such time limit prescribed. an advocate who has an substantial experience in the field of indirect tax litigation for 10 years. So as we can see, for especially for the advocates, after it was amended in August 2024, the advocate now is in another the advocate is now allowed to be a judicial member, and he is required to have an experience of 10 years at least in the matter in the field of indirect taxation, and that to litigation. Again, but the minimum age prescribed is 50 years and the maximum age is 67 years. We do not know how and till what time the people would wait to be the judicial member. So it's personally I feel it's a very the minimum age should have been still reduced, but however I think they need a particular experienced person, relevant experienced person to be sitting on that chair and deciding the cases. Hence the minimum age is 50 years. Now, the technical member would be a member of the Indian Revenue Services, Customs, and having experience in the customs and indirect taxes, or he could be All India Services, in All India Service with 25 years of service in Group A and 3 years of experience in existing laws of or GST administration. So we can see that the for the all India service, 25 years is required in service group A, and 3 years of experience is mandatory in the existing law and GST administration in particular. So I definitely agree that any technical member at least should have some GST background to decide the GST cases, to dispose of the GST appeals. So very rightly. However, although being a chartered accountant, also I miss chartered accountants in this entire chart. So I think they should have more technical people here who have knowledge of the taxation, and also could consider the chartered accountants to be part of this. Again, now this was for the central. Now the technical members, they should have the only difference is they should have state government experience. So must have been an officer in the state government. Rest all other India services experience, which again of 25 years in group A, and again as similar to the central member, 3 years of experience in the existing laws or GST administration or finance and taxation department, of course, which is required if being a technical member. We need this, and the maximum age is 67 years as of now, which is prescribed. If it will be extended, we never know. We have to wait for that. As we have already discussed in the earlier slides, that the appellate tribunal has been vested with certain powers. Now the power of the appellate tribunal is just not bound by the code of civil procedures. It shall be guided by the principles of natural justice also, and the appellate tribunal will have its own procedures and provisions all and rules. So they in these manners they can have prescribe their own procedures, and any of course through the GST council meetings, the amendments will keep coming into these procedures and rules, and any extensions which are required in extensions of any time limits. The as I've already mentioned, that the powers of civil court is also the GST Appellate Tribunal also have the powers of the civil court, and we all know that the powers of the civil court are replicated in so many different forums. So so many different tribunals have the similar powers. However, we'll just run through these powers, that they can summon and enforce the attendance of any person and examine them on oath, which we have also seen in the metropolitan. In certain cases, these powers are vested with the metropolitan courts also, uh, and the civil courts also. Then requiring the discovery and production of documents, receiving evidence on affidavits, requisitioning any public record or document, or a copy of such record or document from any office. So they can, if during the proceedings, if they feel that they wish to have any document, they certainly exercise this power, and they can approach any of the department. Maybe if you have presence in any other state, they can also approach any other office of that state, and they can exercise the power, and they can get those records. Issuing commissions for examination of witness or documents, dismissing a representation for default or deciding it ex parte. So there are specific rules which have been laid out in the entire procedure, which states that if the respondent is not there during the time of hearing, the case will be decided ex parte. So yes, they have the power to decide ex parte. Setting aside any order of dismissal of any representation for default of any order passed by it ex parte. So they can also rectify if the order was passed, sorry, ex parte. So they can definitely dismiss the same, and they can consider it any other matter which may be prescribed. So these are how the order would be enforced, and how the what is the act, how this order will be treated. So the order passed by the appellate tribunal will be considered to be a decree made by the court, as similar as to the order passed by any court in a suit proceeding. It will have the same enforcement. Then we have, if the company, how they can serve the orders, how the it shall be lawful that the appellate tribunal will be sent to the execution of the orders. So if in case of the company, the registered office of the company. However, in case of any other person, the place where the person voluntarily resides or carries on the business or personally works for gain. So we have to see that even though it will be lawful, even if the orders are executed on the place where the person personally works for gain. So this is very important. On the business premise, we all know we usually receive. However, now anywhere, if he is working personally also for any gain, then yes, it will be considered to be enforced. Now, these are the deemed judicial proceedings, which are simply telling us that how the appellate tribunal shall be deemed to be doing the judicial proceedings within the meaning of Indian Penal Code. Of course, they will have in the criminal proceedings, and how the tribunal would be considered to be the civil code for the purpose of, again, criminal procedure. So this entire section is trying to again highlight the powers which will be given to the appellate tribunal in the deemed judicial proceedings. So now we from here we start the entire procedure on how the appeals will be filed before the appellate tribunal. So this so there are around 124 rules. I'm repeating it again and again so that we all register this in our minds, that we have at least from 1 to 124 rules states out only the procedure of filing the appeal before the appellate tribunal. Now, the computation of 3 months period. How would the computation of 3 months period would be considered? Okay, so simple. It's very simple. If there is any holiday, or if the office of the tribunal is closed, or it is if the tribunal is not operating due to certain reasons on a particular day, those days shall be excluded. And the days from, if the last day expires on the day when the office is appellate is closed, then that shall be included, as that shall be categorically excluded. So 3 months shall be from the date of communication of the order. What would be the sitting and working hours? So the sitting hours would be from 10:30 a.m. to 1:30 p.m. and 2:30 p.m. to 4:30 p.m. So as we can see, only 5 hours effectively the tribunal would be operating. Okay, and after that, but however, the administrative office of the tribunal would be operating from 9:30 a.m. to 6 p.m. on all the weekdays. So although the hearings would be specifically conducted for like 5 hours, but the working hours of the administrative office would be from 9:30 a.m. to 6 p.m. So any other formalities which are to be done with the administrative office shall be can be done through the between these hours, between 9:30 to 6:36 p.m. Now, what are the inherent powers of the tribunal? As we have seen, the appellate tribunal has inherent powers to make such orders for meetings, uh, for meeting the end of justice and to prevent abuse of the process of any appellate tribunal. So, if any during the proceedings, if there is any abuse, or uh, if the matter is not, if while the hearing it is not feeling the appellate tribunal is not feeling it to be relevant, it can always process the orders against so listing of the cases. So any urgent matter which is to be filed has to be filed before 12 p.m. and shall be listed on the same working day. So until it is so if it's filed until 12 p.m., then that will be considered for the following day, else it will be considered on the next day. However, only in very exceptional circumstances, when they will consider the listing of the cases, and it can be received between 12 to 3 p.m. However, a specific permission of the president or the appellate tribunal is required. Sorry. Now, powers to exempt. So appellate tribunal has been vested with the powers to exempt any party from any particular compliance and any practice or procedure. So if there is, they can always exempt from submitting any particular documents, any evidence. They have all the powers and they can always waive off the particular requirement if again the substantial cause is given, and if they feel that it is necessary for the case to be to it is necessary for the case. Powers to extend the time limit, again, if this is very important, again they have the powers to extend any time limit which was originally listed out by the in the procedure. They can always extend the time limit which is defined to take up the proceedings or the completion of the proceedings, or for any act which is to be completed, and they can always allow the authorities to extend such timelines and complete the proceedings. Although the application for the same is not made until the expiration of the time appointed or allowed. So now adjournment. All the adjournments shall be obviously first sought with the concerned bench only. So ऐसे नहीं है कि we are filing appeal in one bench and we are trying to get the adjournment in the different bench. No, we have, wherever we have filed the appeal, the hearing would be in that particular bench, and we have to file adjournment with that particular bench only. However, the registrar only in specific circumstances and as directed by the appellate tribunal may allow such an adjournment at in any other bench. Filing of appeal. Now, there are a lot of ambiguities in this filing of appeal and all the procedures. However, the the right now the procedure states are that all the appeals shall be filed only on the GST portal and on the GStat portal in the manner in the form prescribed, which is APL 05, and the single appeal for if there are multiple show cause notices or refund claims, we have to file single appeal for each order in original. We cannot club it. And the single appeal for each order in original also, if the multiple order in original is there, even if though it's with DGGI, if the same matter is there, EWB, multiple place of business, a single appeal has to be filed for each order in original. If there are a multiple order in original, then issued to multiple persons, then each person will have to file separate appeal. Documents to be submitted along with the appeals: a certified copy, definitely a certified copy has to be submitted of the order, and with the relevant annexures and documents as stated. And of course, all the we have to prepare a proper index. The appeal has to be divided into different paragraph, it has to be numbered, all the parties to be appeal has to be specifically mentioned, along with the full name, GSTIN description, and the tax, the dispute involved. So the until all these is completed, the appeal will not to be considered to be complete. Hence, we have to ensure that we are mentioning all the caller, all the particulars which are required. All the relevant documents we can I can share the annexure. What are the annexures? Of course, the annexures are there. Then along with that, there are certain forms which are to be submitted, which we can read through. Now, endorsement and verification. So, appeal has to be signed. Now, this is important for the people who are practicing and who are appointing consultants also, that all the appeals and pleadings shall be signed and verified by the party concerned first. So, if I am a taxpayer and I am filing an appeal, I have to sign on each page of the appeal, on the foot of the page of every appeal. Also, if there is any authorized representative who is appearing on my behalf, and if he is appearing, if he is representing my case, then he has to also put his name and signature and initials on each and every page. So I think this is pretty normal, which was also there in the first appeal also. However, it's not mandatory in the first appeal, but in this case, it is mandatory. So now the authorized representative have to be very careful, because usually we see that the consultants uh, sometimes are reluctant to initial on every page, and usually the authorized signatory of the company is only signing the initial, making the initials on the first page. But however, this they have made it mandatory that all the authorized representatives will have to initial. Now, translation of document, they have clearly stated that the document has to be in English language, and if it is not, if the order in original was not in the English language, then you have to get a translated copy in English language mandatorily. So this is again on the taxpayer, I'm sure, because we cannot expect the department to give the order in original in the local language, sorry, in the translated language in English language. So again, the responsibility is on the taxpayer to get a true translated copy by the authorized representative in English language. So any this is a respondent, if there is any appeal, if the appeal or an application is filed by the person other than the commissioner concerned shall be made the respondent to the appeal or the applications as may be. So in this case, they are just simply mentioning that the commissioner shall be made the respondent to the appeal. This is on the filing of the rejoinder, that whether respondent states such additional facts, the bench may allow the petitioner to file a rejoinder to reply filed by the respondent. But however, the advance copy is to be served upon the respondent within 1 month, or within such time limits as may be prescribed by the bench. So we are saying that we have to at least give 1 month time to the respondent to respond. We cannot expect like we are giving the copy a week before. So they have to be given a relevant time period. Now, daily cause list, as we have already seen that the clock every day the cause list shall be given for the next day of the clause, for the next day which the cases which shall be listed, and the closing, and every day before the closing working hours the cases for the next day shall be listed. Serving of notice and communications. So any notice or communication to be issued by the appellate tribunal will be served in the manner as specified in section 169, which I've already stated that section 169 states that how the manner will be in the 5 ways in which section in the communication is issued, which is through tendering of through courier, or maybe through registered post or the speed post with the acknowledgement. We have to ensure that we keep the acknowledgements with us, or by sending a communication to his mail address. So even though if we are getting it on the email, and at the time of the which was provided at the time of the registration, that means whatever email id is on your portal, if the order is served on that email, then it will be considered to be a proper notice served properly. Then if it is made available on the common portal, then if it is also by publication in the newspaper circulating in the locality in which the taxable person or the person to whom it is issued is known to have been resided or carrying business. So even if it's published in the newspaper, it will be served, it would be considered to be a proper communication. So we have to be very careful that we have to keep visiting our common portals, and we have to keep checking our email IDs. There is a recent judgment where we could see that they have stated that if you are issuing an order on the portal on a particular section, and if you are seeing that there is no response, or if you are issuing any order on a particular email id and you're not getting the response, then the authorities should consider to be issuing it on some other through some other mode also. Just merely sending reminders on one particular email id is not serving of proper notice. So this is a very last month only we got this judgment. So I think this will help us, because sometimes we see that the reminders keep coming up. However, since the email IDs are not updated, we miss out on such orders. So we have to be very careful. We have to be very witty and vigilant that all our email IDs are updated and somebody is constantly tracking the portal. Hearing of appeal. So if the appellant is not if the appellant does not appear, the appellant tribunal may at its discretion dismiss the appeal or for the default, or hear it and decide it on the merits. So again, this is on the discretion of the appellate tribunal. Appellate tribunal may set aside the dismissal order and restore the appeal if the appellant later on comes back and satisfies the tribunal with the sufficient cause of non-appearance in the earlier instance. So if again, I think this is on all account of principle of natural justice. They do consider the cause, however it has to be valid and sufficient, and they do admit the case. Now, hearing of appeals ex parte, as I've already mentioned, if the appellant appears and the respondent is not appearing, the tribunal may hear and decide the case ex parte. In case of difference of opinion in the bench, so yes, if there is any difference of opinion of if there is any difference of opinion of the members in the bench while hearing the appeal shall be referred to the larger bench by the president, or the president may decide as it may deem fit to him, that if it has to be heard by the another bench of the same state, or if it has to be heard by the larger bench again. So it is on totally on the discretion of the president. Production of additional evidence. So this is very important. Again, the parties of the appeal shall not be entitled to produce any additional evidence, either oral or documentary, before the appellate tribunal, which were not taken in consideration while we have filed our appeals with the first appellate authority. However, if if the appellate tribunal thinks and is of the opinion that any document shall be produced uh, to enable him to pass any orders for any sufficient cause, and without and if the case decided in by the first appellate authority without taking in considerations of the documents which were submitted by the documents which were submitted by the taxpayer, he may then allow to produce and he may allow submission of additional documents, either oral or written. Again, the appellate tribunal may, for the reasons to be recorded, allow such documents to be produced, or witness to be examined, or affidavits to be filed, or such evidence to be adduced. Again, so the reasons will be recorded in writing to give any additional evidence. So we come to now Rule 112, which states out if there is no additional evidence which can be produced before the gestat, and which here too were not produced in the course of the producing, as I've already mentioned, no additional if this was not produced before the earlier proceedings, you will not be allowed to produce the certain evidence. However, in exceptional cases, where which is mentioned as here, that earlier authority has refused to admit any evidence, we commonly see that in the initial phase of hearings, that due to shortage of time, the orders are passed. The orders are passed without giving any hearing opportunities, without considering all the evidences and documents which are submitted. The orders are passed without, which are non-speaking orders. In all such cases, definitely following the principle of natural justice, the tribunal will give us an opportunity to submit additional evidences. So earlier order passed without giving any sufficient opportunity for to adduce evidence relevant to any ground. So however, I think we will have to make one specific application to them stating all our causes, that why we are now producing this evidence which were not produced earlier. And if yes, if all these conditions are satisfied, it will be certainly allowed. Adjudicating authority or any officer shall be allowed to examine and cross-examine any evidence or document, or to produce any evidence or a witness to the rebuttal of the evidence produced. So definitely, once the matter is remanded back to the original adjudicating authority, it shall be allowed to examine any evidence or to produce any evidence for helping the tribunal to decide the case. Now, the stat has the powers to direct the production of any evidence to enable to dispose of the appeal. Authorized representative. So authorized representative, we have to know who can be the authorized representative. It could be the any person who's employee of the company, who, or a consultant who is a chartered accountant, or an advocate. However, it is very important that any authorized representative is coming with a proper wakalatnama, or a memorandum of appearance, or a letter of authorization. It has to be in a proper format Few states have their own state requirements. They require it on the stamp paper. They would require it on the stamp paper of say 100 rupees. So we have to see how the requirement would roll out in future. They may clarify on this that if they have any particular format for authorization. But however, until it's not stated, the wakalatnama memorandum and of appearance on a simple letter of authorization signed by the directors of the company will also suffice. Now it should also include the information which is specifically rolled out in GSTAT form 04, consent for change of authorized representative. So if at all there is a change in the legal practitioner or the authorized representative which was supposed to appear for our cases, and now he has refused to attend, then only with the permission of the appellate tribunal we can do so. So we have to obtain prior approval of the authorized we have to obtain prior approval of the appellate tribunal to do so. Again, operation of operative portion of the order. So all the orders or directions of the bench shall be stated in clear and precise terms in the last paragraph of the order. Rule 116 states out again who can be the authorized representatives, as I've already mentioned, to that any relative or regular employee of the company, an advocate, CA, CMA, CS holding a certificate, retired officer of the commercial tax department, or any authorized GST practitioner is authorized to appear on behalf of the authorized representative, can be the authorized representative. Pronouncement of order. The appellate tribunal shall pronounce an order not later than the 30 days from the date of final hearing, excluding the vacation or holidays. So, as we all know, there is no time limit to pronounce the order. Okay, so here also, if we see, it is mentioned from the date of final hearing. So, we would not know when the date of final hearing would be given. So, yes, at least from the now how the final hearing is, either any document issued for the hearing would state that this is the final hearing order, no, final hearing notice. So that would be considered as the final hearing, or and from there 30 days will be counted, or else it will be discussed between the appellate tribunal and definitely the appellant, that this is the final hearing, and post which we will not be discussing any further on this matter. So that shall be concluded as the final hearing, and from that 30 days shall be given to the appellate tribunal to pronounce the order. However, the word final hearing, again, we would not know when the final hearing would conclude. So again, this time limit for pronouncement of order uh, is only from the 30 days of the hearing. It's not actually stating any number of years within which the order has to be pronounced. Now again, if there is any period is fixed or under these rules by the or granted by the appellate tribunal, they have the powers, and on its discretion they can and on in the interest of the justice, they can enlarge such period, and they can even if the period was fixed by the rules or granted by the appellate tribunal, they can still enlarge it. They have the powers to enlarge such time period. There is a lot of ambiguity which is going on in the electronic filing of the appeal. There are few open issues also. However, as that if we fail to file the appeal electronically, then how we will not be able to file the appeal manually. So certainly we would be able to file the appeal manually, as we've seen, and we have to take a specific permission from the registrar and the president. And I am hoping that in future, after the clarifications shall be issued, we will be more clear on how even on the digital signature, if it is an online appeal, digital signature is sufficient. However, on the manual appeal, will the manual signature work, or is it compulsory that the document should be digitally signed or manually signed? Both the signatures would work. A lot of small ambiguity is still persisting. So we are hoping that once the tribunal is operational, I think there would be more clarification in the while which will be issued. So if we can see, every appeal or application to be filed shall be uploaded electronically on the GSTAT portal. It will be signed, verified, and uploaded, and all the documents supporting has to be uploaded. Now, what if another open question is, what if the size of the document is so huge that we are not able to upload? So can we be able to submit it manually or on some email IDs? Again, that clarification, this is an open issue, this could come to anyone's mind. So there are so many instances in now also that the portal has restrictions of certain number of space where we could enter the, where we are able to upload the appeal, the additional documents, and we are not able to because of the size restriction. So hopefully we should be able to submit it manually in future if required. How, as of now, there is no particular clarification on the same. All the replies filed and documents shall be signed, verified, and uploaded electronically. All the proceedings before the appellate tribunal shall be conducted through the GSTAT portal only. So, of course, this is trying to tell us that the hearings could be in physical mode also, or through the video conferencing. Both will be available. Uh, the Nowadays they have already started the in the first appellate authority hearings also, we can see that the online mode video conferencing is now made mandatory, and we can always choose to opt that. Earlier it was compulsory to be physically present. Now they have started giving this facility of video conferencing. So similarly, this would be allowed with the appellate tribunals also. All these proceedings shall be recorded on the said portal. A summary of the final order passed by the by the appellate tribunal shall be uploaded. So all the hearings before the appellate tribunal may be conducted either in the physical mode or upon the permission of the president in the electronic mode. So, if the tribunal deems it fit that any award for the cost for meeting of any legal expenses of the respondent is to be given by the defaulting party, it can definitely announce that cost. It will be part of the order which will be pronounced, and the cost of meeting the legal expenses has to be bared by the defaulting party. And further, if it's the appellate tribunal may also uh, in suitable cases direct the either the appellant or the respondent to bear the litigation cost, and in case of in case of abuse of the process of the court, impose exemplary cost on defaulting party. So again, this is very important. So this could be anything, and exemplary cost itself states that this will not be tolerated if there is any abuse in the court process. So we have to strictly abide by the court process, and we have a huge list of documents and forms to be filled in while appearing for the tribunal. Again, authorized how also they have specified a very particular dress code which should be worn by the female or the male appearance. So one second. Yes. So the authorized representative shall appear in the professional dress, of course, and it has to be proper formals. And the as also we have seen in the CSTAT also, we could see that the black and white dress code was specifically made mandatory. Similarly, for the males, a closed collared black coat or in an open collared black coat with a white shirt and a black tie is mandatory. And for the females, they have to wear a white sari or any white dress. However, it has to a black coat overcoat is mandatory. Only the only exception they has given is for the summer season, which is from 15th of April to the 31st of August, and where the where we can dispense off with the requirement of wearing a black coat, because obviously in the summers we cannot always carry the coat. So to that extent we have been allowed exemption. Withdrawal of the appeal. I'm sorry, my throat. This rule deals with the withdrawal of the appeal, of course, and how if it at all at any stage before the application is before the order is issued, before the order is pronounced, the appeal can be withdrawn before the GST Appellate Tribunal. The appellant may withdraw the appeal by filing an application at any time before the issuance of the of course, the order of the GST Appellate Tribunal, and in case where the final acknowledgement has been issued by the for the appeal, the withdrawal of the appeal is required to be approved by the GST Appellate Tribunal. Until then, in this case, we will not be able to withdraw the appeal if it is not approved by the tribunal. So these are the key decisions where the waiver of the pre-deposit was allowed. I will just come to this in the later stage because we have more things to cover. And the code of conduct, what we would want to, the suggestions we would wish to make is, while we want to be fully prepared for the appellate tribunal, appearing before the tribunal, so we should always be ready with one pager synopsis, which is followed by a detailed synopsis also. So this is very crucial. We should not be, as we have already seen in our earlier adjudication also, we should not be messing up with the documents in front of the officer, and we are presenting, we are not knowing which point is where. So we should have a synopsis which is just capturing the important highlights of the appeal, and followed by a detailed synopsis also, which is also covering important judgments, maybe the evidences, the annexures. And the synopsis has to be very crisp, and it has to be, the para numbers, the referencing, the page numbers has to be very clear in the synopsis. All the case laws relevant should be in hand, so that you are able to immediately produce those case laws. Then there are five set of synopses which should be prepared, and the case laws, so that we are able to give the two sets to the tribunal, one set to the department, one is our copy and one for the acknowledgement. So okay, so yeah, five sets and along with the separate case law. Okay, then obviously the file, we should know our file correctly. We should know what are the points, what we want to say in those, because we will not hardly barely get some time with the tribunal. So we should be very sure on what we want to say, where we want to say, and what is mentioned where. Each and every paragraph has to be so the procedure also lays out that there is a how much gap we have to have in each para. So 2.5 is the 2 point in the indexation should be of 5 inches, and they have clearly stated out the how the respondent, the department shall be filing an appeal. So what is the format of that appeal? The paragraph spacing has to be 2.5, and it has to be properly numbered. All the we have to be marking all the portion of the case laws which are relevant, or any agreements or any documents. Everything should be properly highlighted. And obviously we have to give all the case laws, and we have to also anticipate the any case laws on which the department could be relying on. We have to also be prepared, keep it handy, and we have to be prepared for the same, that if in case such a case law is also given by the cross case law is given by the department, how would we be defending the same. Okay, so always carry a digital file also to record the proceedings, because we may miss out on certain details which are to be recorded on a piece of paper, and then we are not ready. We should not be doing so. And we should be always present at least half an hour before, or at least 15-20 minutes before the proceedings of the tribunal are commencing. Okay, we have to carry the cause list also, and we show that we, and it's the our case should be clearly highlighted along with the timings. Then you these are the basic points. Then you are assist to the court, take your first best point, of course. If you know that this is the best, you the merits are on this particular point, and it could be cost basis on the bad point, that point has to be set first. Of course, the face value matters, means of course if there is somebody who is more known to the department, may help you in better presenting your case, so you have to of course choose them wisely, and choose your consultants or the authorized representative very wisely. Okay, so we do not always have to fight only on the technical issues on the first instance. We have to fight on the general issues also, like principle of natural justice, or say where the errors are committed by the department in the signatures or exceeding authorities. So those points are also to be considered. Technical issues, certainly yes, they are very important, but we never know if sometime the general issues would help us better. While the hearing is going on, we should not cross. Try to be very humble and respectful. We should, but however, we have to be very firm in making uh, we have to be very firm in making our contestations, and we have to be sure that at least we are making our point while being very respectful for the authorities which are sitting there, while the judicial and the technical members, because they are too learned, and they should be heard. So we should not unnecessarily open our mouth where it's not required. We have to respect the also the respondent who is arguing the case, and we have to be very respectful to them, even though if during the hearing they are trying to raise voice, we have to be respectful. Don't interrupt the judge while they are speaking, of course. And if there is any need, we can ask if for adjustments with the adjournments with the valid reasons. If we are not ready with certain documents, request the appellate tribunal the to give you adjournments. Do not try to lie or breach the trust of the judges, because certainly you will lose your case right there, if they will not feel that you are presenting the right facts to them. You should know your judges. You should know the any decisions if there were pronounced which were in the favor or in the similar matter. You should always bring out those kind of judgments, and we should always have a research ready for those kind of judgments. We should always know that if there is any judgment which was positively pronounced in the similar matter by the same judge, it will really help you in fighting the case. Then the language should be very simple and persuasive. The dress code has to be followed. The forms and the formats, if there is any specific requirement by any specific tribunal bench, please ensure that you know it in prior, and we are following that. Then we have to obviously rebut the opposing counsel, but we have to be defensive. However, we have to be not to be argument we sorry we have to be strongly putting forth our point. We have to be firm, but we should not get defensive over them. We should know when to conclude the hearing. Again, these are the simple things which I've brought out from the practical experience, that the we have to study the file and see the hearing intimation, confirm the correct file. Sometimes we go for the hearings and we are not aware that this was not our hearing, so this should not happen, right? So a day before we should definitely check the availability of the hearing officer and study the file properly. Synopsis should be, again, as we mentioned, do not print it which is not inside the file. The synopsis should be only based on the files which we have, only based on the facts which we have mentioned in the detailed appeal. Then we have to understand, know our grounds very thoroughly, see the documentary evidences which are available. If you come across any alternative points which was missing, we have to request, as we have seen, we have to request the bench to allow that point and take up a permission from them and should be added. uh, okay, again, the two sets have to be printed out of the synopsis, which I've already said. Now I will just quickly run you through the few judgments which were pronounced, in which cases the waiver of pre-deposit was allowed. So in this case, in this case, the waiver of pre-deposit was allowed only on this basis because of the financial hardship of the appellant, or where the procedural justice was overlooked. So in this particular case of Mr. Muhammaddin Akmam and Akmamuddin versus Commissioner of Appeals, he has mentioned that his company has faced losses and he is not able to pay the pre-deposit. In such cases, definitely they do consider the waiver of pre-deposit, and it was allowed. So we can always take the reference of these three cases. If if either of your, some of your situation is falling in this particular case. Then there was so this is the main this is a detailed case which you can always go through if you wish to, if it is helping. So I'll just quickly read out the gist of this. The court has the discretionary power to grant the waiver when a strong justification is demonstrated, such as inadequate reasons for penalty imposition, imposing pre-deposit without disable business operations, and petitioner having a very limited means to pay. So, as mentioned, that in this case, the petitioner was just the daily wage earner. He was facing a lot of hardship and he could not pay, pay the pre deposit, and the precedent was set for future cases that it will be the pre deposit will be set aside where the cases are involving financial distress. In this case, the case was decided in favor of the appellant because the case was unjust and the commissioner has dropped the demand for the earlier period without any further appeal. Again, in the case of government of Andhra Pradesh, others versus P. Lakshmi Devi. Again, the case, in this case, the Honorable Supreme Court has constitutionally upheld a mandatory piece, which was 50% of mandatory deposit was to be deposited with if there was a deficit in the stamp duty for making a reference to the collector. However, in this case, he has waived off this, and he has mentioned that the party may not be able to pay this amount of exorbitant duty demanded, and he has again waived off the pre-deposit in this case. This is the, again, this would be very helpful for all of us because most of us would be struggling with the condonation of delay. We all know that we have so many of us might have missed filing of appeals within the period of 3 months, which is allowed under section 107. So in such cases, we have few judgments which will help us to get the condemnation of delay. And of course, the tribunal will be in the initial phase, would be definitely allowing us to get the waiver on the get the condemnation of delay, because a lot of appeals which were coming from the matters of 17 and 18 19 could not be attended and could not be filed in time due to so many back to back litigations which each and every taxpayer was facing. So followed by ASMT 10 show cause notices, different due dates. So there was many multiple litigation which was going on, so might possible that so many of us might have missed. So yes, we can apply for condonation of delay. So this is the section which is stating out how the condonation of delay would be. I'll just quickly refer this. And so any person aggrieved by an order passed by against him under the section 107 or 108 of the SGST Act or UGST Act may appeal to the appellate tribunal against the order which within 3 months from the date on which the order sought to be appealed against is communicated to the person preferring the appeal. 3 months after the expiry of the period referred to in subsection 1. So this is again saying that the cross objections can be filed within the 45 days period. And if it is satisfied the sufficient cause was not presented, then they may not also allow the condonation of delay. They say these are the few judgments which you can refer for the again if there is there are any procedural lapses which you have done, and we can go through if the period of extension is required. So the few cases which we can refer where the condonation of delay was allowed beyond the prescribed time limits which are mentioned under 100 and section 7. Hello, Bhavna. One minute. Okay. No. I think we have like few questions, but before I go on to the questions, I just have missed out on a small comparison I would want to highlight between the systat and the gstat. So a very good part, so what has in the systat, the it was mandatory for everybody to file an appeal in A5, uh, or the legal paper, but however in the gstat they have allowed to for submit appeals in the A4 size paper. However, the double spacing is made mandatory, and the English translations are mandated, which was not in the CSTAT. While we filed appeal in the CSTAT, then authority. So the practice was to be more evolved in the past decisions in during the CSTAT. However, the GSTAT is more focused on the explicit registrations, powers, and procedural timelines, which are specifically rolled out by the GSTAT. Hearing process again in the CSTAT, it was open court and it was not digitized. I in the GSTAT, the this is at least hybrid, and they have allowed us to be allowed us video conferencing and the chamber hearings or the restricted public access if it is there. So at least we are given an option to go to be to present our case through video conferencing mode also, which was not in the CSTAT. Now the cause list was in the CSTAT given weekly. However, in the GSTAT, it is made this cause list is compulsory to be given daily before the closing of the work hours, and also the urgent matters can be listed until 12 p.m. and 12 p.m., and it will be taken up on the following day itself. And also in exceptional cases between 12 to 3 p.m. also, if until 3 p.m. also we are receiving those cases, it will be taken up, provided it is specifically approved by the president and the registrar. So this is again a very good point that the cause list will be daily. Adjournment of the cases, it was in the during the CSTAT, it was based on the simply the CSTAT may adjourn on the terms and conditions it may think fit. However, here the in the exceptional cases, the case can be referred to the registrar, and the matters can be definitely adjourned with the specific permission of the registrar also. Withdrawal of the appeal. So the GSTAT was not providing any specific rules or procedures for the withdrawal of appeal, and for the withdrawal of the appeal. However, in the GSTAT, they have specifically an option. They have specifically specified the rules for withdrawal of the appeal before issuance of the order. In the CSTAT, it was not clearly mentioning that that the withdrawal can be done before or after or the hearings. The pre-deposit again, during the SISTAT, it was 7.5% of the tax, disputed tax. It was capped, but however, in the GSTAT, it is 10% of the disputed tax, which is leading to a heavier compliance burden as compared to the SISTAT, because already 10% of the pre-deposit we deposit during the first appellate authority, and and now with the GSTAT again it's made 10%. I think they should consider to reduce this filing. They should consider to reduce this disputed taxes. Sorry, this pre-deposit. Now the fee. The appeal filing fee was 10,000 in case of SISTAT. However, in case of GSTAT, it is made 25,000, which is again very hefty, and it will be heavy compliance for all the taxpayers who would want to appeal in the GSTAT. And miscellaneous fee again, it was 500, like the bare minimum fee, it was earlier 500. However, now in the GSTAT, it is made 5,000, again a heavier compliance. So if we see, uh, so filing fee wise, or the penalty, or sorry, or the pre-deposit wise, the compliances have become heavy, pocket pinching for the taxpayers, for the for the appellants. So yes, I let's see if there would be representations to reduce this filing fee, because it 25,000 is a huge amount to be paid for on as a filing fee alone. So a lot of working capital gets blocked. So, I think the tribunal should consider to reduce this fee. Monetary limits again, for the filing of appeal with the tribunal earlier was 50 lakh for the sistat. However, they have reduced such a monetary limit for the revenue. This was these, so as I've already specified, this monetary limit was for the revenue. So 50 lakh rupees was the earlier monetary limit for the revenue to file an appeal to the appellate tribunal. However, it has been reduced to 20 lakhs in the GSTAT. I will just now quickly see the questions. 1 minute. Okay. So, I'll start with, I think we have many questions. Yeah. What are the audit tools are available? So audit tools means exactly what I am unable to understand. Audit tools with the assessee, with the taxpayer, or with the department. If you could clarify the same. Why court fee is required when pre-deposit already is paid as per the act? So I think if we have already seen that the earlier in the CSTAT also this court fee was required. So yes, the court fee is was part of the CSTAT also, and however, yes, they have increased the court fee, which should not be the case. Yeah, the same as I was talking about, they should consider the they should consider reducing such fee. And if they could waive off, if nothing like it, because a lot of companies will save their working capital. What is the is there any time limit within which they are supposed to conclude the appeal? So as I've already mentioned, no, there is no particular time limit for them to conclude any appeal. But however, yes, from the date of final hearing, from 30 days from the date of the final hearing, they have to pronounce the order. There is no time limit as of now. If we win the case at appeals, the department is neither releasing the advance amount nor filing in tribunal, then what to do in such cases? No, so if we are winning the cases, certainly we will have to apply for the release of the refund. We will have to apply for the refund. And I think once the refund is applied, we have to once the refund is applied, I think within 1 or 2 months, maybe a maximum by 6 months, they have to release the amount of pre-deposit advance which was given. And actually the refund has to be along with the interest on the pre-deposit. So that is one more thing they should be doing. Now, there's one question. What if we make payment under DRC 03? How can the same be adjusted? So if you're making payment through DRC 03, Circular 224 already specifies the procedure that we can link it through DRC 03A, and we can always adjust the pre-deposit paid in DRC 03 to DRC 03A. 10% pre-deposit is over and above the 10%, which yes. So the question is, the 10% pre-deposit is over and above the 10% paid during the first appellate authority. Yes. So yes, definitely this is over and above the 10% which was paid to the first appellate authority. Right. Will the tribunal be given powers to condone the appeals which have been filed late? Yes, I think yes, the tribunal has the powers to condone the appeals which were filed late, and I think those will be the first cases which will be, I think, preferred and remanded back to the adjudicating authorities. So I think these were all the questions I have covered. I think Minal has asked us again, audit tool is convenient for reducing the risks. So, Minal, I think you are asking about the audit tools which will help the appellate tribunal, I think, to for the audit risk, or it is or the audit tools which are available for the litigation. I think you're asking for litigation. Yes, you are right that the audit tools are definitely convenient for reducing the risks. And so, in the procedures, at least, there is no mention of the audit tools. If there is any clarifications which would come, maybe you can send me your email ID and I can get back on I have your mail ID, maybe we can get back to you. I think I have taken up all the questions. So, Impit, if there are any other questions, you may highlight it to me.
So, ma'am, there are no further questions. Thanks a lot for deliberating such an in-depth session, in-depth knowledge on the topic. Thank you. Thank you for sparing your valuable time and effort.
I'm sorry, my video was off. Yeah.
Yeah, ma'am, thanks for taking the session and the questions. Bhargav, we can sign off for the day.